Parental responsibilities don't depend upon how the child came into the world. Parental responsibilities extend to adoptive parents who had nothing to do with the creation of the child physically. They extend to in-laws and to grandparents and a host of other people who are not involved in any way, in at least directly, in the creation of the child as a human being.
Well, Your Honor, with respect to adoptive children, yes, the state does make arrangements, and it does create in-law a relationship that is in all aspects, virtually all aspects, identical to a natural and biological relationship. It does that, again, for the sake of the children, for the sake of the upbringing of children, and creates, with respect to those children, rights and responsibilities in their adoptive parents that are the natural result of natural procreation.
Well, vis-a-vis the state's interest in the well-being of children, isn't the state indifferent with respect to how the child was conceived, whether the child was conceived in a marriage or outside of a marriage or in some other fashion? Once the child exists as a human being, the state has some interest in the well-being of that child, wholly apart from whether the child was born in a marriage or out of a marriage or in some other fashion.
Yes, Your Honor, it does, and it really is the point. That really is the point. The state has an interest in the child. It cannot ignore the society's larger and community's interest in that child. And the state's concern is that if that child is born in a context other than a committed relationship, a marital relationship between the man and a woman who created that child and brought it into life and who have taken responsibility themselves, as marriage as a social institution is designed to encourage and promote that when a child is not born into that situation, yes, the state still has an interest in that child. The community does. And the state must step forward oftentimes and, again, take responsibility itself for the upbringing and the support and the education of that child, whether it's through extraordinary measures, such as when the child has neither its own mother nor its father, and the state has to take full responsibility effectively for the child, or if the child still has, and in the vast bulk of the situations where this actually arises, the child still has a relationship with its natural mother, but the mother or the single parent, mother or father, doesn't have the same ability and support as a marital union to raise that child, and certainly not to provide the child with two parents to look after it, let alone two parents that are composed of both a paternal and a maternal parental role model. So it is, you have put your finger on the key. The state has an interest in that child. In fact, it has an interest in all children, and that's why the state and every society for the millennia, Your Honor, has attempted to channel naturally procreative sexual conduct between men and women into an enduring union, an enduring, stable union for the sake primarily of those children.
Let's move from the millennia to the 3 weeks in January when we had this trial. What does the evidence show? What does the evidence in this case show with respect to this?
Thank you, Your Honor. I believe the evidence shows overwhelmingly that this procreative, this interest in what many call, and the United States Congress calls, responsible procreation is really at the heart of society's interest in regulating marriage.
Okay.
Because, for example, what the evidence shows is that imminent. I'm sorry.
I'm just.
Thank you.
What was the witness who offered the testimony? What was it, and so forth?
Yes, Your Honor. The evidence before you shows that Sociologist Kingsley Davis, in his words, has described the universal societal interest in marriage and definition as social recognition and approval of a couple engaging in sexual intercourse and marrying and rearing offspring. Blackstone, Your Honor, said that there are two great relations in private life. First, that of husband and wife, which is founded in nature, but modified by civil society, with nature directing man to continue and multiply his species, and civil society, the social society's interest, prescribing the manner in which that natural impulse must be confined and regulated. And the second great relationship, according to Blackstone, that of parent and child, which is consequential to that of marriage, being its principal end and design. It is by virtue of this relation that infants are protected, maintained, and educated. Your Honor, I mentioned earlier another great lawyer, Justice Stevens, who himself, in his dissent in Bauer, said that marriage is a license to cohabit and to produce legitimate children. That's what it has been, what it has always been. This understanding of marriage, Your Honor, is before you from eminent authority after eminent authority in a range
I don't mean to be flip, but Blackstone didn't testify, Kingsley Davis didn't testify. What testimony in this case supports the proposition?
Your Honor, these materials are before you. They are evidence before you. But Mr. Blankenhorn brought forward these authorities, and that's the social scientists and anthropologists and sociologists and others. But, Your Honor, you don't have to have evidence for this from these authorities. This is in the case themselves. The cases recognize this one after another.
I don't have to have evidence.
You don't have to have evidence of this point if one court after another has recognized. Let me turn to the California cases on this. The first purpose of matrimony by the laws of nature and society is procreation. The California Supreme Court said that shortly after statehood. A century later, the California Supreme Court re-emphasized that the institution of marriage serves the public interest because it channels biological drives. Channels biological drives that might otherwise become socially destructive, and it ensures the care and education of every children in a stable environment. That's the California Supreme Court, Your Honor. That's the purpose of marriage in this state, according to the California Supreme Court in DeBerg against DeBerg. 2 years ago, less than 2 years ago, the California Court of Appeals held that the sexual procreative and child-rearing aspects of marriage go to the very essence of the marriage relation. Your Honor, Congress, in passing DOMA, said the core purpose of marriage is this. At bottom, civil society has an interest in maintaining and protecting the institution of heterosexual marriage because it has a deep and abiding interest in encouraging responsible procreation and child rearing. Simply put, government has an interest in marriage because it has an interest in children. Your Honor, most of the courts, quite a substantial majority of the courts that have looked at the issue that is before you now have upheld the constitutionality of the traditional definition of marriage because, and these are the Eighth Circuit's words, in upholding a provision enacted by the people of Nebraska that is word for word identical to the one before you. It upheld it because this is the Eighth Circuit Court of Appeals in 2006. The state's interest in steering procreation into marriage justifies conferring and the inducements of marital recognition and benefits on opposite-sex couples who can otherwise produce children by accident, but not on same-sex couples who cannot. At least two-thirds, Your Honor, or just approximately anyway, two-thirds of all the judges who have looked at this issue that is before you now have upheld the traditional, or would have, some of them are in dissenting opinions, or would have upheld the traditional definition of marriage on this rationale. The majority of Congress enacted DOMA, as I just mentioned, on this rationale. And the plaintiffs say there is no way to understand why anyone would support Proposition 8, why anyone would support the traditional definition of marriage except through some irrational and dark motivation, some animus, some kind of bigotry, Your Honor. And that is not just a slur on 7 million Californians who supported Proposition 8. It's a slur on 70 of 108 judges who have upheld as constitutional and rational the decision of voters and legislatures to preserve the traditional definition of marriage. It denies the good faith of Congress, not just these judges, of Congress, of state legislature after state legislature and electorate after electorate.
Let me ask, if you've got 7 million Californians who took this position, 70 judges, as you pointed out, and this long history, as you have described, why in this case did you present but one witness on the subject? One witness. You had a lot to choose from. You had that many people behind you, but why only one witness? And I think to say that his testimony was equivocal in some respects.
Certainly not on this one, Your Honor. And his testimony was utterly unnecessary for this proposition, utterly unnecessary for this proposition.
So that goes back to the you don't need any evidence point.
Well, Your Honor, it goes to, again, these are legislative facts. You need only go back to your chambers, Your Honor, and pull down any dictionary, pull down any book that discusses marriage, and you will find this procreative purpose at its heart wherever you go. Unless, Your Honor, that book was written by one of their experts or has been written over the last 30 years, then you will find, yes, that procreation, what has that got to do with marriage? What? And the pages of history, Your Honor, are filled with nothing but this understanding of marriage. You will not find anywhere in the pages of history, nowhere, any suggestion that the traditional definition of marriage, ubiquitous in history, across cultures, across time, had anything whatever to do with homosexuality. Had nothing to do with it. In fact, the issue of people's values with respect to homosexual conduct was never in the marriage conversation until the movement for same-sex marriage. Your Honor, at the heart, at the very heart...
What should I conclude from that?
That, Your Honor, at least an important purpose of marriage always has been and still is to channel naturally procreative sexual conduct of men and women into enduring, stable family units through marriage so that the children of that union will be raised by the man and woman who brought them in to improve the likelihood that will happen.
What has changed in the last 30 years that has dramatically altered the landscape you've just described?
Your Honor, I think my point is the changes in the last 30 years haven't eliminated that legitimate and important purpose of marriage.
But you've pointed out that there is this body of opinion, this point of view that you've described that now views marriage as an option for homosexuals. Okay. So that's something that's developed in the last 30 years. What is it, and what does the evidence show has prompted this change? Why do we have this? If it has never been a debatable proposition before, why is it now debatable?
Well, it has become a claim, and an understandable claim, which, Your Honor, we respect and credit. Credit certainly the sincerity and the passion behind the desire of same-sex couples to get married. And that movement has developed, and it has made this issue a very important controversial issue of public policy. And it's one that is, as you know, not just taking place here in California. It's taking place elsewhere in the country, and voters and legislators have come to some different conclusions. It's taking place throughout the world, but, Your Honor, the issue is...
If it's taking place throughout the country, throughout the world in this fashion, then doesn't that indicate a changed perspective with respect to the role and function of marriage in society?
In the minds of many, yes, Your Honor, in the minds of many.
And then doesn't that affect then the responsibility and the extent of appropriate authority and regulation by the state of the institution of marriage?
I think, Your Honor, I think states are examining their responsibilities with respect to this issue currently, and have been over a number of years now, and that in the political process, which, given that this issue goes more to the morals of a people than any other relation, as again we know from the Maynard case, that this issue is being debated in the political process, and it has brought forward additional considerations and issues for the legislative process to grapple with. But the real question, Your Honor, for you is this. Has something happened with respect to the nature of marriage, the legitimate purpose of marriage to make the historic, consistent, and ubiquitous core procreative purpose of marriage no longer constitutionally legitimate? Are the competing considerations which the political process is grappling with on a daily basis here, are those competing considerations so overwhelming that it's no longer legitimate for the people of California or the legislatures of this country or the Congress or court after court to conclude that there is a legitimate function and purpose of marriage that does bring forward a distinguishing characteristic relevant to interests the state is able to implement? Those words, Your Honor, are, I think, verbatim. The words of case after case regarding when it is appropriate for the society, for the state to draw distinctions whether or not there is a distinguishing characteristic relevant to this core procreative purpose, Your Honor. That justifies and explains the rationality of a preference by legislators or a preference by voters to and a rational basis for maintaining the historic traditional definition of marriage.
Let me ask you. You heard Mr. Olson this morning recount the experience of and the background of the Loving decision by the Supreme Court in 1964. I think it was 67. And up to that point, numerous states had laws on the books which prohibited interracial marriage. And at some point, there came exactly the same kind of social change that you just described with respect to homosexuality. And at some point, 1967, that matured into a constitutional recognition of a constitutional right, the limitation against interracial marriage violated a fundamental individual right under the Constitution. Why are we not at the same tipping point here with respect to same-sex marriage?
Oh, Your Honor, several reasons. Among the most important, perhaps the most important, is this. What legitimate purpose of marriage, recognized historically or anywhere else, justified, provided a rational basis for the state of Virginia or any other to say that an interracial couple could not get married? Well, it certainly was this core procreative purpose that I'm mentioning because, Your Honor, that purpose was frustrated by those policies. That purpose actually was at war with the overriding ubiquitous core procreative purpose of marriage because it required people who had interracial couples
excuse me for interrupting, but you recall a number of the decisions which upheld those laws, and the rationale that was used by the courts in some of those cases was that the mixing of the races was going to be destructive. It would have serious corrosive effects on society.
Your Honor, those racist sentiments and policies had no foundation in the historical purpose of marriage, and in fact, again, they were at war with it. Racial restrictions on marriage were not part of the common law. As we have maintained from the beginning, the opposite-sex nature of marriage is itself definitional. Definitional because of again, the Supreme Court has often recognized because this relationship is fundamental to the existence and survival of the human race. So the opposite-sex nature of marriage has always been definitional. The common law didn't place racial restrictions on marriage. Many states did not place racial restrictions on marriage. Only 16 states at the time of Loving still had racial restrictions on marriage. They grew out of this very particular racist, white supremacist theory, Your Honor, that was at war with all the legitimate purposes of marriage. They actually made people have illegitimate children, illegitimate natural children, which again was the purpose of marriage, as Justice Stevens says, is to license cohabitation and produce legitimate children. That was the purpose of it. Well, this racial restriction was at war with its very definition, its very nature. Second point I want to make is that these restrictions
Why is the limitation on marriage for gay couples and lesbian couples similarly at war with their desires to raise children, raise their own children in the context of a marriage partnership?
Your Honor, again, this is the distinction that the Eighth Circuit Court recognized and that case after case has recognized. There are distinguishing characteristics relevant to the interest that the state is pursuing here. As the Eighth Circuit Court said, Your Honor, only opposite-sex couples can procreate naturally, and therefore it is only opposite-sex couples who uniquely address this fundamental historic purpose and who present, most importantly, uniquely, the threat to the society's interest that marriage is designed to minimize. The threat of irresponsible procreation. The threat, the reality that when procreative sexual relationships between men and women are not channeled into marriage and these stable unions with these binding vows, then much more frequently the society has to itself cope with the adverse social ramifications and consequences of that kind of irresponsible procreation.
But you don't draw any distinction between the state's interest with respect to marriage and children of that marriage the parents have been able to conceive on their own, and the situation where an opposite-sex couple have had to require some form of intervention, a medical intervention or otherwise, in order to produce children, an increasingly common situation. And the rights and responsibilities of the parents are exactly the same for the children of the latter couple, and the state's interest is exactly the same, is it not?
Your Honor, they are not quite the same, no.
Well, then what's the difference? You mean, where you have to have an egg donor or a sperm donor or some procedure of that kind in order to produce a child, the state's interest is different in that child and in that marriage?
Your Honor, the first point I wanted to make is to refer back to earlier colloquy and discussion with respect to the interests that are served by permitting all opposite-sex couples to marry without attempting to use some kind of intrusive inquiries and what have you into questions of fertility, questions of, desire to have children and what have you. I didn't at that time also mention that the society's interests are also furthered whenever opposite-sex couples are married in order to engage in sexual relationships, because that strengthens the social norms that really the legal institution of marriage relies upon most heavily in order for this channeling function to be performed. It would be, whenever couples, opposite-sex couples are in cohabitating relationships, as they, as it certainly happens now that they are more often than in previous times in history, that in and of itself weakens those social norms that seek to encourage and to channel those types of procreative relationships into marriage. But to come back specifically to your point, Your Honor, I really think the state's main concern, or certainly among the state's main concern in regulating marriage, in seeking to channel naturally procreative sexual conduct into stable and enduring unions, is to minimize what I would call irresponsible procreation. It's not a good term, but I can't think of a more serviceable one. And that is procreation that is bound by the kinds of obligations and social norms that the marital relationship is, and that often leads to children being raised by one parent or the other, or sometimes neither parent. That is the phenomenon that is uniquely centered on naturally procreative sexual relationships between men and women. It is not a phenomenon that the state has to be concerned about with respect to same-sex couples. For a same-sex couple to procreate, by definition, has to be responsible. It can't be by accident. That's the key point. And that's a point that the Eighth Circuit Court itself stressed in the Bruning case that I quoted from earlier. By definition, same-sex couples do not naturally procreate, and when they procreate...
My point was that there are a number of heterosexual couples who do not naturally procreate, who require the intervention of some third party or some medical assistance of some kind.
Yes, Your Honor, and it is not those opposite-sex couples either that the state is concerned about in terms of the threats to society and the natural concerns that society has from irresponsible procreation.
What's the threat to society of people choosing to have medical assistance in order to conceive children?
There isn't one, Your Honor. I mean, it is the... Again, it's irresponsible procreation, the procreation that comes about casually. And often, again, as the Eighth Circuit put it, often by accident, unintentionally, the opposite sex couple where one of the partners is infertile, for example, or the same-sex couple can't unintentionally procreate, but for reasons that we discussed earlier with respect to the opposite sex but infertile couple, allowing them to marry isn't something that is inconsistent with the purposes of the core procreative purposes of marriage, and in fact, in certain respects, it advances the purposes, and it would just not be possible or realistic, as case after case has said, for the state to try and implement its policy on a more narrow or fitted basis. And Your Honor, with respect to, and you asked a question about this in your written questions, even with respect to the opposite sex couple where one of the partners is infertile, encouraging that couple to get married, trying to channel that couple into marriage furthers the procreative purposes and policies underlying the traditional definition of marriage, in the sense that if that couple gets married, then then all of the social norms that come from with marriage to encourage that couple to stay together and be faithful to one another operate to society's benefit, in the sense that the fertile member of that couple will be less likely to engage in sexual relationships with third parties and raise a new threat of some type of unintentional or what I've been referring to previously as irresponsible procreation.
Why don't those same values, which are values to society that you've described, apply to lesbian couples and gay couples, coming together, supporting one another, taking care of one another, looking out for one another, being an economic unit, being a social unit, providing love, comfort, support for one another? Why don't all of those considerations apply just as much to the plaintiffs here as they apply to John and Jane Doe, to use the terms that Reverend Tam used?
Well, those purposes, Your Honor, we haven't suggested there is a distinction among gay and opposite-sex couples with respect to those considerations. There is a distinction, however, with respect to the fundamental procreative purpose, responsible procreative purpose of marriage, and that is that the gay couple, unlike the opposite-sex couple where one of the partners may be infertile, doesn't represent neither partner in the with respect to the same-sex couple is, again, assuming homosexual sexual orientation, represents a concern about irresponsible procreation with a third party. But, Your Honor, the considerations that you have identified are considerations that the state and its voters have taken account of, and they have respected and they have credited and they have honored by creating the parallel institution of domestic partnership.
What does the evidence show that the procreative function of marriage was a rationale of the voters in enacting Proposition 8? What's the evidence on that, the evidence in this record?
Well, Your Honor, there is substantial evidence in this record. First, Your Honor, is the ballot arguments themselves in the official voter information guide. The Yes on 8 position favoring Proposition 8 specifically said, Proposition 8 protects marriage as an essential institution of society. While a death, a divorce, or other circumstances may prevent the ideal, the best situation for the child is to be raised by a mother and a father, a married mother and father. So, Your Honor, the central thrust of the responsible procreation purpose of marriage was to put forward in the voter information guide itself, but the campaign, also the Yes on 8, the protectmarriage.com, Yes on 8 campaign spoke to this. It is not accurate to say that there was no discussion of this concern or this interest in connection with a campaign, in connection with the formal Yes on 8 or protectmarriage.com campaign, because there were advocacy pieces after advocacy pieces that spoke specifically to this issue. One was a video ad which said...
Is this in the record?
Yes, Your Honor.
What is it? What exhibit?
PX 97. Marriage involves a complex web of social, legal, and spiritual commitments that bind men and women for one overriding societal purpose: to create a loving environment for the raising up of children. In a range of written advocacy pieces, Your Honor, printed materials, the protectmarriage.com said things like this. And this is actually from a PX 27 that I'm going to be reading from. The marriage of a man and a woman has been at the heart of society since the beginning of time. It promotes the ideal opportunity for children to be raised by a mother and a father, and a family held together by legal, communal, and spiritual bonds of marriage. And while divorce and death do frequently disrupt the ideal, as a society we should put the best interests of children first, and that is traditional marriage. Your Honor, there were a number of, and there are before you a number of those things from the Protect Marriage campaign itself. But beyond that, quite beyond that, this was a frequent theme within the religious community that was, as you know, quite active in the debate in the political process over Proposition 8. The campaign wasn't just by any stretch what protectmarriage.com had to say to the people. The debate was a cacophony of ideas and of arguments and of debates ranging from the fairly ubiquitous television ads throughout that, or at least towards the November 4th itself, that appeared on television, to conversations at the office water cooler. Your Honor, people got there, debated this issue in every venue and every forum, in civic centers. It was a cacophony of issues, and certainly one doesn't have to pinpoint a particular argument from a particular source to conclude that virtually any argument that would have supported one side or the other was being advanced by these very passionate debates. Your Honor, the other point I want to make about this, and it goes to the issue of standard to review that the court will be applying in this case, is this. We submit, of course, as you know, the rational basis test applies. There has not been a case in the so-called marriage equality cases that has been applied the federal Constitution that has applied any other standard of review. And in fact, beyond that, Your Honor, there has not been a case in the federal judicial area, or as far as we can tell, the state judiciary looking at the sexual orientation classification that has applied anything other than rational basis review, with 4 exceptions. There are 4 district court cases that have applied some form of heightened scrutiny. The Ninth Circuit, we submit to you, has binding, controlling authority on this question from the high-tech gays case. 10 other circuit courts of appeals, 6 of those cases with 6 decisions coming after Lawrence, have held it to the same effect. No court of appeals case has ever applied anything other than rational basis review to a sexual orientation classification. And out of 40-some odd district court cases, only 4 have done so, and all 4 have been reversed. Supporting the plaintiffs on the question of standard of review is nothing, and there is a judicial tsunami that they are asking you to sail into on this question. So we believe that rational basis applies, and that if we are right and rational basis applies, the state, or we, as we attempt to step into the shoes of the state, don't have to submit evidence to the court in support of the claims of purpose and justification. To the contrary, the plaintiffs have to negate every conceivable rational basis that might explain the policy at issue, the classification at issue. And, Your Honor, what that means is they have to negative every conceivable state of facts that could provide a rational basis for the classification. This is stated in case after rational basis case, Your Honor, from Garrett and Heller and FCC against Beach, as the court knows from its own questions. And if the state of facts that would support, if it was any conceivable state of facts that would support the classification is even arguable or debatable, as you asked Mr. Olson, then the state's policy must be upheld. It must be a non-debatable preposition. So if you conclude, and here is the perhaps I guess kind of the most important point of this purpose, even if you conclude that in fact, by a preponderance of the evidence, they are right on any of their claims, that doesn't matter. You still must rule for the state unless you also conclude that the legislative facts on which the classification is apparently based could not reasonably be conceived to be true. Vance against Bradley. It's not that who is right or who is wrong. It's that no rational person could conceive that the legislative fact relevant to the issue could possibly be true.
The standard of review in Romer was rational basis?
Yes, Your Honor. And Romer, Your Honor, applying that standard, concluded that there was no explanation for the sweeping, disabling, punitive statute discriminating against gays and lesbians in that case. Not any explanation that could provide any rational basis for the rule there. So the only conclusion that could be arrived at was that it flowed from animus. It flowed from animus. That was the only thing that could explain the sweeping, disabling statute that effectively, in the court's words, made gays and lesbians strangers to the law. Made them strangers to the law. Placed them effectively outside of the law's protections, effectively permanently, or at least until the electorate amended the Constitution.
Mr. Olson contends that Proposition 8 makes gays and lesbians strangers to the institution of marriage in California. Let me direct you to the Minnesota versus Cloverleaf, and just one sentence by Justice Brennan on this rational basis review standard that we've been discussing. Where there was evidence before the legislature reasonably supporting the classification, litigants may not procure invalidation of the legislation merely by tendering evidence in court that the legislature was mistaken. So where was the evidence here, as I understand your argument? Where was this evidence with respect to the natural procreative capability of heterosexual couples or opposite-sex couples as opposed to the non-natural procreative ability of same-sex couples? Now, that is the evidence that was before the voters here that you are relying upon as providing the rational basis. Am I correct?
Forgive me, Your Honor. I'm not sure I follow what.
Well, and perhaps it wasn't stated very well. But the point that Justice Brennan, I think, was making is that Minnesota case, there was evidence before the legislature. It was identified. It wasn't simply some rationale pulled out of thin air. There was evidence before the legislature to warrant the classification that was made in that case. And this was a classification, as I remember correctly, between paperboard milk cartons and plastic milk cartons. Well, the evidence supporting the classification here that you are contending exists is this natural procreative ability of opposite-sex couples, which distinguishes them from same-sex couples. That is the evidence. Am I correct?
That's certainly a premise. Yes, Your Honor.
That's it.
It's a premise of the responsible procreation rationale.
Let me ask you, while we have a pause in our discussion, unless you want to move on to something else that follows immediately, about one of the answers that you provided in the response to the written questions, which was actually the last question. The question was, if the court finds Proposition 8 to be unconstitutional, what remedy would yield the constitutional expression of the people of California's will? And your response?
I'm sorry, which question was that?
The last question, number 15.
This is the common...
Exactly, the common questions to both plaintiffs and proponents. And I'm reading from pages 45 to 46 of your response. And your response was, if, as plaintiffs maintain, Proposition 8 cannot be reconciled with its own non-retrospective application as interpreted by the California Supreme Court or with any other feature of California law, the remedy that would yield to the constitutional expression of the people of California's will is sustaining Proposition 8 by giving it retrospective effect or invalidating the conflicting feature of California law. Do I understand that what you're saying here is that not only am I required to rule against the plaintiffs, but to invalidate the 18,000 marriages, same-sex marriages that occurred between June and November of 2008?
No, Your Honor, that is not our position at all.
But that's what these words say, do they not?
Well, no. No. Only if there is only some irreconcilable conflict between those two things, as Mr. Olson maintains, but we dispute that there is an irreconcilable conflict. This goes to at least what we perceive the court's question to be going to, is the plaintiff's argument with respect to the so-called crazy quilt that has been created by Proposition 8 and the interpretation of Proposition 8, in particular in the marriage cases that interpreted Proposition 8 to be prospective only and not to invalidate the 18,000 or so same-sex marriages that took place during the interim period after the decision and before Proposition 8 was passed. Our position, we disagree with Mr. Olson. We don't believe that there has created a conflict that requires Proposition 8 to be invalidated. That's what he is arguing. That is that it is irrational, he thinks, to have valid same-sex marriages in the face of Proposition 8's prohibition on same-sex marriages going forward, at least under the marriage case's interpretation of its prospective only effect. Our answer is the court of California Supreme Court simply engaged in analysis that is quite routine and standard when statutes or constitutional amendments are enacted that would affect rights. At least on their face value, face would appear to affect rights and interests that have been created under the pre-existing state of the law. This pre-existing state of the law being the not quite 5-month period when same-sex marriage was legal and same-sex marriages were entered into. The court, the California Supreme Court simply said these reliance interests that have been created as a result of the court's previous decision. And here I'm referring to the Strauss case where Proposition 8 was at issue and it was interpreted as prospective only. That those reliance interests were the court thought powerful and legitimate, and that it was effectively loath to interpret Proposition 8 as upsetting those interests. So Proposition 8 would be given only that prospective effect. It's not at all uncommon when courts are faced with that kind of situation, and not all that uncommon, really, when legislators are, and they decide to cut back on something to grandfather the individuals, as it is commonly called, to grandfather those interests and protect them from the application, which would, in that circumstance, be especially harsh in consideration of the reliance interests that have been created under the previous regime. We don't think that's irrational. We don't think those two realities create some irrational and unconstitutional crazy quilt. And neither did the California Supreme Court. But all we are saying in our answer is this: if that were to be the case,
if what were to be the case,
if it were to be the case that Mr. Olson is right, and the prospective effect and the 18,000 marriages that took place before the passage of Proposition 8 and Proposition 8's own prospective effect can't be reconciled, and one or the other has to fail, our submission is the overriding constitutional judgment of the people is not what would fail here. Proposition 8 should not be invalidated because of some notion that there is irreconcilable conflict between it as a prospective statute and the existence of reliance interests that compelled the California Supreme Court not to apply Proposition 8 retrospectively. Obviously, it was before the court to apply, and it could have, and were certainly, legislative arguments that Proposition 8 had a retrospective effect as well. Just as you, Your Honor, the California Supreme Court held in a previous case that marriages that had taken place under what was ultimately determined to be a void act of ordinance or whatever in San Francisco, that all of those marriages were void. Well, that was a decision the California Supreme Court could have rendered. It decided not to. We think these things can lie down comfortably along one another. There is not any rational conflict, so it is not our position. We urge you not to conclude that one or the other of these or these elements must fail. We don't think that is necessary.
One or the other of what elements?
Well, Proposition 8 as a prospective prohibition on same-sex marriage on the one hand, and California Supreme Court's interpretation of it allowing the 18,000 same-sex marriages that had taken place before its enactment to remain valid. We think that grandfathering effectively of those marriages is perfectly rational, and it's perfectly common and perfectly constitutional. Your Honor, I want to effectively conclude this piece of my argument by calling the Court's attention to a case from the 11th Circuit called Lofton. It was a case in which the 11th Circuit upheld Florida statute that prohibited gay adoptions. At the heart of that case was this consideration that we have been discussing. That is effectively the core procreative element or purpose of marriage, and the idea that, which was displayed again, and as I mentioned earlier, in the official ballot initiative argument, that it is, and that many people believe that it is best for a child to be raised by the child's own mother and father. What the court there concluded, and I might add that the expert for the plaintiffs in that case was Dr. Lamb. Ultimately, the court concluded that, in fact, the evidence submitted there by Dr. Lamb was adequate to render irrational the common sense belief that children do best when they are raised by their own mother and father, which in one of your questions, Your Honor, you'll recall quoting from the New York Court of Appeals in Hernandez against Robles, that common sense proposition. And this is what ultimately the 11th Circuit was persuaded by. Taking all of this available information into account, the legislature could rationally conclude that a family environment with married opposite-sex parents remains the optimal social structure in which to bear children, and that the raising of children by same-sex couples who, by definition, cannot be the two sole biological parents of a child and cannot provide children with a parental authority figure of each gender, presents an alternative structure for child rearing that has not yet proved itself, beyond reasonable scientific dispute, to be as optimal as the biological-based marriage norm. Your Honor, this again brings forward the point that the standard here is whether or not the evidence produced by the plaintiffs is more than just opinion evidence, but it actually rises to the level of non-debative scientific facts. And ultimately, the 11th Circuit concluded that that was not, in that case anyway, that simply couldn't be said with respect to the common sense belief that many, many, many people hold, and many researchers hold, that the optimal child-rearing parental structure is the traditional intact family. Your Honor, I want to move, if I may, to an area that the plaintiffs have emphasized. They have gone to great lengths to underscore the religious beliefs of many of the people who campaigned and supported Proposition 8. It's hardly remarkable in our country that religious beliefs are and religious people are involved in the political process. It's part of our constitutional tradition, from the American Revolution to the abolitionist movement to the civil rights movement. And there are issues, many of them, that confront the legislatures, that confront the body politic, that are bound up and inextricably involve moral values and moral judgments, from the death penalty, gambling, obscenity, prostitution, and an issue that was before the Supreme Court not that long ago in the Glucksberg case, the issue of assisted suicide. The court there rejected a substantive due process challenge to a state statute that prohibited physician-assisted suicide. And the court noted that throughout the nation, Americans are engaged in an earnest and profound debate about the morality, legality, and practicality of physician-assisted suicide. And the court held that the Constitution permits this debate to continue, as it should in any democratic society. And, Your Honor, the court was very careful to make clear that when a court is presented with a claim of asking the court to define some new fundamental right, that the court must very carefully analyze that claim and must insist that it be rooted, deeply rooted, in the country's history and traditions in order to protect against the judiciary unnecessarily taking important issues off the table of the democratic process. This is true also of marriage. We would submit.
You concede there are times when it is appropriate for the courts to do exactly that.
Yes, of course.
Now, we've talked about the Loving decision, and we've talked about the Brown decision and various others.
Yes.
What are the criteria that a court should use in making that determination?
Your Honor, I think I think the criteria is what the Supreme Court itself has articulated, that the right claimed must be deeply rooted in the history, traditions, and practices.
And in this case, marriage is a deeply rooted and fundamental right.
Yes, Your Honor.
No doubt about that.
Yes.
Okay.
Your Honor.
And that, as Mr. Olson described this morning, is a right that extends essentially to all persons, whether they're capable of producing children, whether they're incarcerated, whether they're behind in the child support payments. There really is no limitation except, as Mr. Olson pointed out, a gender limitation.
Well, Your Honor, and that gender limitation is a definitional feature of the right to marry, a definitional feature. That is clear from the court's repeated statement that the reason marriage is fundamental is that it is fundamental to the existence and survival of the human race. It is procreative.
Because it is a gender-specific right?
The right...
That's what you're saying?
Yes, I am. The right is...
Gender-specific.
The right to marry is bound up with and proceeds from the fundamental nature and its fundamental purpose relating to procreation and the existence and survival of the human race. So it is itself, by definition, the right of a man to marry a woman and vice versa. That is the right. And, Your Honor...
All right, then. Let me ask you something about that you said in one of the other responses to the written questions. This is number 9. I believe this was a question posed to both parties. On page 21 of their response.
I don't have the same pagination you do. I'm sorry, Your Honor. Is it 9 to both parties?
I beg your pardon. It's number 10. Number 10. If it helps, the ribbon is document 687, page 25 of 50. And you say, with respect to sexual orientation, as a socially constructed category, sexual orientation clearly fails the requirement. And the requirement positive is, social constructivism suggests that there is nothing real about sexual orientation except society's construction of it. And not surprisingly, social constructionists generally reject the possibility of biological factors in sexual orientation. Now, what that leads me to ask you is, aren't these distinctions that we're drawing, sexual orientation distinctions, gender distinctions from a legal point of view, are they not all socially constructed?
No, Your Honor. I think there would be a fundamental difference, at least if I understand the thrust of this inquiry between, for example, the gender distinction and a distinction drawn along the lines of sexual orientation. Because we took this and the notion of social construction to go to what we think are the very difficult issues surrounding sexual orientation and its amorphous, effectively indefinable, at least consistently, nature and the simple fact that it is not immutable.